1.2 General legal principles applicable to a life insurance agent. While each province has its own legislation, the provinces and territories have all based their respective insurance legislation on a model statute created in the 1920s in cooperation with a body called the Uniform Law Conference. This is why insurance legislation applicable in every Canadian jurisdiction except Quebec is very similar. Having more uniform practices and procedures when dealing with life insurance contracts is helpful to clients and to insurers, regardless of the province in which they are located. If a policyholder moves to another province after the policy is issued, that province's laws will apply to certain aspects of their estate planning, such as their will. However, the law that applies to the interpretation of an insurance contract, including the naming of beneficiaries, will be the law of the province or territory where the policy was contracted. Fortunately, the statutory basis for the creation and treatment of insurance contracts in the various provinces and territories is very similar. The result is consistent treatment of legal principles and their application to the life insurance agent's business. These relevant legal principles that arise from common law or from statutory law statutes are addressed in the following order: capacity and status of persons, natural persons, partnerships and legal persons, corporations, minors and guardians, powers of attorney, POA, marriage and common law unions, divorce and separation, wills, estates and successions, trusts and trustees, and bankruptcy. Capacity and status of persons. In addition to a minimum age, the law requires that anyone of any age who is seeking to enter into any contract must have legal capacity to contract. From a legal standpoint, the concept of capacity relates to a person's ability to provide valid consent. This excerpt illustrates the legal definition presumed for legal capacity in Ontario. 2. 1. A person who is 18 years of age or more is presumed to be capable of entering into a contract. And Section 2. A person who is 16 years of age or more is presumed to be capable of giving or refusing consent in connection with his or her own personal care. The capacity to enter into a contract means the individual is capable of understanding the terms of the contract and that they're entering into a binding agreement, even if they do not know all the details. Individuals who are mentally incapable lack the legal capacity to give a valid consent and therefore to enter into a contract, including an insurance contract. There is no recognized maximum age at which a person is presumed to be incapable of giving valid consent age. Therefore, a 100-year-old person is still presumed by law to have the legal capacity to enter into a contract. Natural persons, partnerships and legal persons, corporations. It is important to understand that a distinction is made between a natural person, a partnership, and a legal person, a corporation. Natural persons, individuals. A natural person is defined as a human being. A natural person with legal capacity has the ability to make decisions about their person and property and to bear the risks and rewards of those decisions. This personal autonomy includes the right to enter into contracts. The term individual is also used in legislation, including taxation, to describe a natural person. Partnerships. A partnership is an arrangement between two or more parties carrying on business together with a view to making a profit. The partners themselves can be individuals or corporations. In an ordinary partnership, all partners may sign the contract on behalf of the partnership, and each partner is financially liable for contracts entered into by other partners on behalf of the partnership. Some partnerships enjoy a statutory limitation on partner liability created by the relevant provincial statute. These are called limited liability partnerships, and they are a common business arrangement for lawyers and accountants. Legal person. Corporation. A corporation is a legal person. In other words, it can be described as a separate entity from those that manage or own it. Corporations effectively have most of the property rights of individuals, and so can enter into contracts and buy, sell, and own all kinds of property. The forms of corporations for businesses differ from the forms for charities and not-for-profits. Business corporations are owned by shareholders, who can be either individuals, other corporations, or partnerships. According to the federal or provincial laws under which they are established, corporations are governed by a board of directors elected by the shareholders. Under the authority of the directors, the corporation can delegate authority to various executive parties called officers, such as the president, vice president, etc. When a corporation seeks to make a contract or transact business, someone must sign on behalf of the corporation. This person is usually referred to as a signing officer. Executive officers such as the president or secretary are authorized, usually by a corporate bylaw or a resolution of the board of directors, to represent the company in specific transactions or activities. Insurance applications often call for the signatures of two officers or directors, or ask the person signing to indicate that they are one of the persons, or perhaps the only one, authorized to sign on behalf of the corporation. Minors and guardians. The rights to legal autonomy, previously mentioned, have not yet been acquired by minors, who are persons under what is called the age of majority. The age of majority varies from one province or territory to another. It was formerly age 21, but has been reduced to age 18 in Alberta, Manitoba, Ontario, Prince Edward Island, Quebec, and Saskatchewan. It is age 19 in British Columbia, New Brunswick, Newfoundland and Labrador, Nova Scotia, Northwest Territories, Nunavut, and the Yukon. However, provincial insurance legislation says that for contracting a policy, but not as a beneficiary receiving death benefits, a person 16 years of age or older has the capacity to contract for insurance on its own behalf. Parents of minors aged 15 and under without the capacity to contract a life or accident and sickness insurance policy have an insurable interest in their children and may apply for a life insurance policy in their name. In some provinces, parents also have the right, as guardian of their minor child, to give consent on behalf of the child to conduct some financial transactions. Where it applies, this parental right is conferred by some provincial statute. In their will, parents can appoint a guardian for their minor children and authorize the executor or estate trustee to make payments to such guardian. A guardian of minors may also be appointed by a court. Grandparents, aunts and uncles, or even older siblings or foster parents may apply for and take on this role in the absence or incapacity of the actual parent. A court-appointed guardian is important in insurance practice for two main reasons. First, if a death benefit is payable to a minor, the guardian may be entitled to accept the payment and discharge the insurer from its obligations under the contract. Second, if insurance is being applied for on behalf of a minor as the life insured and there is no parent, it may be the guardian who will be answering questions on behalf of young minors and completing the application. The guardian will also give consent on behalf of the minor to the release of medical information to support the underwriting of the application. If there is no person capable of giving and authorized to give a valid discharge to the insurer for the insurance money, The insurer shall, within 30 days after receiving the evidence required, pay the money and any applicable interest into court into the credit of the minor. In that case, the money will be managed by an official connected with the public trustee, if there is no trustee or court-appointed guardian to receive it. Power of Attorney, POA, and Enduring Power of Attorney. As part of a life insurance agent's practice, the agent must understand the circumstances and legal mechanisms relating to when the rights of an insurance policy are transmitted to another person. This section discusses the transfer of certain rights and its impact in the field of insurance. To address the risks of being unable to look after themselves, personal care, or manage their property, adult individuals may voluntarily appoint a legal representative while they are still capable to represent them and make decisions on their behalf when they are coming to the end of their life or in the case they become incapable. Power of Attorney. A power of attorney is a legal document made by one person who appoints another person called an attorney to deal with the business and property of another person and to make financial and legal decisions on their behalf. A power of attorney can be very specific or very broad. A power of attorney ends if the person who gave the power of attorney becomes mentally incapable. The attorney is also called the agent, and the person appointing the attorney is called the principal. Enduring Power of Attorney. An enduring power of attorney is a legal document made by one person, the principal, who appoints another person, the attorney or agent, to make financial and legal decisions for the principal. An enduring power of attorney will continue even if the principal becomes mentally incapable of making decisions. To create an enduring power of attorney, the document must be properly signed and must state whether the attorney, the person appointed to make decisions, can act while the person is capable or only while the person is incapable, that the attorney's authority continues despite the incapability of the person. A property power of attorney document, depending on its terms, may come into effect immediately, or it may require someone such as a doctor or capacity assessor to trigger its effect. In other words, to determine that the donor of the power has become incapable of managing its own affairs. The attorney, by statute, usually has all the powers required to deal with the owner's property, but not to make a will. In addition, most insurers will refuse a beneficiary designation made by an attorney except if a court order is made to the contrary, or in the case of an annuity contract where there is a transfer of money from another financial institution in the presence of an existing beneficiary designation made with the former financial institution. Otherwise, the attorney would be able to revoke a beneficiary designation made by the principal by transferring monies from one financial institution to another. When it comes to dealing with insurance transactions, insurance agents, before accepting the instructions given by purported power of attorney, should obtain a certified true copy of the power of attorney from a notary public and have it reviewed by the insurance company that will be asked to act upon instructions given under its authority. Insurance agents could be asked by trusting clients to act as their power of attorney and executor and trustee. This arrangement is not covered by professional errors and omissions insurance and could put the insurance agent in a conflict of interest with the client and, potentially, in trouble with the insurance regulator. For these reasons, agents should decline to accept such an appointment, at least without thorough legal advice on the subject beforehand. If an adult becomes incapable and has not appointed a personal representative, a court may appoint someone, including a trust company, to manage their affairs. Trust companies commonly act to manage the finances of incapable adult persons, but will not manage the personal care aspects. Court-appointed guardians of an adult person who has become incapable could transact insurance business concerning an existing policy, such as a term renewal or conversion, or they might buy segregated funds or annuity products as an investment for the incapable, always subject to the authority granted by the terms of the court order appointing them. Unlike enduring powers of attorney, guardianship only comes into effect after a person has been declared incapable. They require the person applying to be appointed as guardian to propose a property management plan for the incapable. Guardians' activities are always subject to review by the court that appointed them. Clients often mistakenly refer to powers of attorney for personal care, POAPC, as living wills. A power of attorney is a legal document in which a specific person is named to act on an individual's behalf. A living will simply addresses your treatment and personal care wishes and does not need to name anyone or be written in any specific way. Nonetheless, treatment wishes, your living will or advance directive, can still be included in a power of attorney document so that the attorney is aware of them. Marriage and common law spouse. Insurance agents will often encounter clients who are single, married, or with common law spouses, or who are experiencing a marriage or relationship breakdown. In the latter situation, a client can be obligated to pay spousal and child support. To do a thorough needs analysis, taking these client obligations into account, and developing a familiarity with how and when support obligations may arise can be helpful. This in turn calls for an understanding of the legal relationships clients may enter into with third parties. It is crucial for agents to understand that the property rights of married spouses usually differ significantly from those of common law spouses when their relationship breaks down. Common law status, with no presumed division, is different from married status, presumed division in this regard. Furthermore, the rights of married spouses to share on an intestacy, the state or condition of dying without a will, are usually dramatically different from those of common law spouses. Marriage is a formal legal status that is acquired and terminated pursuant to federal law, though the format of the marriage celebration is controlled provincially. The legally recognized state of marriage immediately has significant effects on property ownership and civil rights that are subject to provincial and territorial law. It creates both legal rights and obligations. In Canada, any two persons may become married, but individuals may only be formally married to one spouse at a time. Married status is retained until the death of a spouse, the annulment of the marriage, or until a legally valid divorce is granted by court order. Couples may adjust their legal rights before, prenuptial, or during a relationship by entering into a domestic or marriage contract with each other. Common law couples can also enter into a domestic contract, sometimes called a cohabitation agreement. Common law status in most provinces and territories is determined by cohabitation in a conjugal or marriage-like relationship for a specific period of time. Rights acquired under common law spousal status vary widely. In most provinces and territories, common law partners can acquire the right to seek spousal support, if needed, upon relationship breakdown. In addition to support while living together as a couple, common law spouses are sometimes entitled to claim dependence relief in the event of the death of a spouse who failed to make adequate provision for the other. Spousal status is also very important in pension law, where the right to be a surviving beneficiary will be affected by the existence or non-existence of someone else qualifying as a spouse under the terms of the pension plan. Insurance agents can perform a valuable service by advising clients to seek competent legal advice concerning the effects of marriage compared to a common law spouse relationship on their financial and legal arrangements. Divorce and separation. In the event of divorce or separation, the value of the policy may become subject to the valuation and division of property. Insurance proceeds received from a third party may receive preferential treatment, similar to inheritances and gifts, and be excluded from the rebalancing of financial assets. Grounds for divorce are controlled by the Divorce Act, and the right to spousal and/or child support payments on divorce also arises under the Act. Less commonly, marriages are annulled, meaning that they are legally treated as never having been in effect. In either case, the main legal effect is the same. The marriage is dissolved, and the divorced or unmarried persons are free to remarry. Since property rights are under provincial jurisdiction, most changes to financial status, except child support resulting from a divorce, arise from provincial and territorial legislation. The effect of a divorce or separation on insurance needs analysis and beneficiary designation planning is an increasingly complex and important part of insurance law. Family property. All provinces have laws that attempt to determine how spousal wealth and property will be divided when a relationship comes to an end through separation, divorce, or in some cases death. Division may depend on when the property was acquired and from what source. The phrase family property variously implies property that was acquired during the marriage or is used or enjoyed by the family of married spouses, or that generates income that supports the family. Ownership of family property is presumed subject to equal division when the married spousal relationship breaks down, but subject to a judge's discretion. In contrast, property that was acquired prior to the marriage or relationship, or that came from an inheritance during the marriage, usually gets protection from division. The rules are specific to the particular jurisdiction where the couple resides when the relationship ends. Rights to spousal support are separate from, and additional to, a right of property division. All of these rights, given by statute, may be modified by competent adults who enter into a contract by which they modify or even give up rights. Wills, estates, and successions. The term succession law applies to the body of provincial law that deals with deceased persons' estates and the rules governing property passing as a result of a death. The collection of property and property rights that the deceased owned is referred to as their estate. All the provinces and territories of Canada permit an individual to prepare a will, leaving their estate to whomever they wish. People usually also appoint a person to be in charge of the estate. If appointed under a will, that person may be referred to as the executor, male, or executrix, female, or estate trustee, gender neutral. As the person who controls the estate, they have the legal obligation to pay the debts, including taxes, of the deceased from estate assets, and to manage and distribute the remaining assets in accordance with the terms of the will. Not all property owned by an individual is controlled by their will. Ownership of property held in joint tenancy with one or more persons usually passes outside the will. Registered plans with a named beneficiary, including Registered Retirement Savings Plans, RRSP, Registered Retirement Income Funds, RRIF, and Tax-Free Saving Plans, TFSA, pass directly to the named beneficiary. Life insurance, payable to a named beneficiary, also passes outside the will to the named beneficiary. In contrast, life insurance payable to the estate of the policyholder is disposed of under the terms of the will. Surviving spouses under pension law also obtain rights that have priority over designated beneficiaries, legatees, and heirs, which are also received outside the will or the estate. Coupled with will-making, there are strong laws to protect those to whom the deceased owed legal or moral obligations of support. Financially dependent persons, such as a surviving spouse or children, can sue the estate for support if the deceased person owed them a duty of support and failed to make adequate provision. The laws governing this, generically called dependents' relief legislation, give dependents priority before any disposition or distribution under the deceased's will is made. The prior rights of financial dependents and spouses allow them to be adequately provided for, even though they may receive life insurance as a named beneficiary. Such insurance may be considered part of the estate and made subject to an order for the support of dependents. Testate and intestate successions. Clients may or may not have a valid will when they die. If they do, they are said to have died testate with a will. If there is no will, the client is said to have died intestate. Sometimes there is a complete will or a partial will, but no named executor able and willing to act. If there is no will, or no willing or able executor, someone must apply to the court to be put in charge of the estate. If there is a will, the executor will distribute the estate after the payment of the debts according to the will. This person will also be recognized as an administrator or estate trustee. This is usually one or more of the adult beneficiaries who will be inheriting the estate. When there is no will, the estate trustee will distribute the estate in accordance with the applicable provincial rules on intestacy. If there is a will, the executor will distribute the estate after the payment of the debts according to the will. Separation of married partners has no effect on a will, and signing a separation agreement may allow alimony claims to be made against the other spouse's estate, but it does not usually affect voluntary gifts made by will or the designation of beneficiaries. If clients wish to disinherit a former legal spouse, marriage, after separation, they need to change their will and their beneficiary designations and sign a separation agreement. Divorce does not revoke a will either. The will is interpreted as if the former spouse had predeceased the testator. Only the provisions in the will that refer to the spouse are revoked. Likewise, a divorce does not revoke the designated beneficiaries, except in Quebec. In addition, it is important to know that a will made before marriage is automatically revoked upon marriage, unless the will was made with the marriage in mind, with a statement making reference to the upcoming marriage and the name of the spouse. If a policyholder's beneficiary designations contained in a will are revoked, and there is no valid beneficiary designation, the insurance or registered plan proceeds will become payable to the policyholder's estate. When the policyholder dies without a will, the estate will be distributed according to the provincial law that determines who inherits on intestacy. Insurance agents should not hesitate to direct clients to the client's own legal advisors to provide for estate planning or to manage specific life events such as separation or dissolution of marriage. Trusts and trustees. Trusts established during the life of the settlor are called inter vivos trusts between living people. Trusts established upon and as a consequence of someone's death are called testamentary trusts. While guardians and powers of attorney have certain powers over a person's property, they do not take title to the property. In contrast, trustees have legal title, as opposed to equitable title or beneficial ownership to the property given to them in trust. While a power of attorney may choose to act, they generally do not have to do so and may resign. In contrast, once a trust has been created, a trustee is already under a positive legal obligation to act as and when the need arises. A trust is therefore arguably a form of property management for the benefit of the beneficiaries of the trust, considered vulnerable. Put another way, trusts are simply a form of surrogate ownership, where the trustee has title to and control over the trust property with the obligation to distribute them to the beneficiaries of the trust. Insurance proceeds can be used to create a trust fund or to enhance the size of an existing one. Trustees can own any type of property that individuals can, so they can hold an insurance policy, pay the premiums from trust monies as long as necessary, and then either transfer ownership of the policy to the beneficiary or collect and handle the proceeds of the insurance in accordance with the terms of the trust, in other words, as the person who set up the trust directed. Insurance agents should not hesitate to direct clients to the client's own legal advisors to provide for trust and estate planning. Bankruptcy. Individuals may incur more debt than they are ever able to repay. They may have assets and income, but if they are unable to meet their financial obligations as they fall due, they are insolvent. If some creditor formally pushes them to pay a debt, they may decide to make a formal declaration of bankruptcy or be adjudged bankrupt. Either case leads to the appointment of a bankruptcy trustee. The trustee in bankruptcy collects the available assets of the bankrupt person and uses them to the benefit of the bankrupt's creditors, according to the rules in the Bankruptcy and Insolvency Act. Similar policy considerations also underpin laws that provide for particular legal protections to apply to life insurance proceeds. Life insurance or financial products that qualify as life insurance, including life annuities and segregated funds, may qualify for special protection against creditors in the event of an insolvency or bankruptcy of the policyholder. As discussed earlier, when an individual dies, the first duty of the estate representatives is to pay the debts and taxes owed by the deceased. It is entirely possible that there will not be enough money in the estate for all the creditors to be paid. In such a case, the persons named in the deceased individual's will receive nothing, and they may simply refuse the inheritance. An estate might be bankrupt, just as an individual can be bankrupt during their lifetime. However, provincial insurance legislation states that insurance proceeds payable to beneficiaries do not form part of the insured's estate. Since they are not part of the estate, they are not subject to control by the estate's creditors. In addition, while a designation in favor of a spouse, child, grandchild, or parent of a person whose life is insured, or any of them, is in effect, the insurance money and the rights and interests of the insured therein and in the contract are exempt from execution or seizure. Asset protection is one reason that agents usually advise clients to name direct beneficiaries rather than their estate. Another opportunity to create asset protection, even for beneficiaries outside the protected family class, is the irrevocable beneficiary designation. In such a situation, the policy itself, which could have substantial cash values, is also not subject to seizure and cancellation by execution creditors. Generally, the property divisible among creditors must not include any property that is exempt from execution or seizure under any laws applicable in the province within which the property is situated and within which the bankruptcy resides. For beneficiaries to be protected, there must be specific provincial legislation which clearly states that a specific insurance product is exempt from seizure and under what circumstances. For example, in Ontario, the Insurance Act clearly states that when an insured makes an irrevocable beneficiary designation, the insurance money will not be subject to the control of the insured's creditors. The extent of the beneficiary's protection is limited to the terms of the provincial legislation which provides for such protection. The use of irrevocable beneficiary designation is not commonplace, and agents should not hesitate to invite their clients to consult with legal advisors should the facts in a specific case require specialized attention. Please consult Chapter 2 for additional information on this topic. Pension funds, including LIRA, LIF, and annuities purchased with pension funds money, are also generally exempted from seizures. In some jurisdictions, registered products such as RRSP and RRIF are exempt from seizure, even without beneficiary designation, and even if issued by financial institutions other than life insurance companies. It is also important to mention that in every Canadian jurisdiction other than Quebec, it is possible for the owner of certain registered products such as RRSP, RRIF, and TFSA to designate a beneficiary. In that case, the beneficiary will receive the death benefit outside of the estate and avoid probate fees.